This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. This morning I'm going to speak about how an insurer must always act to protect its insured, and that an insurer commits a fatal sin by sitting back and doing nothing, because failure to conduct a full and thorough investigation to protect the insured sued by a third party caused a bad faith judgment in favor of one insurer against another, when all of the insurers who had available coverage should have worked together to resolve the claim on behalf of their mutual insured. Every liability insurer is obligated to conduct a thorough and prompt investigation, and if liability is clear, must pay to resolve the claim to protect the insured. Failure to do so, where a $40 to $50 million potential verdict was faced by three insurers with a $1 million limit each and an offer to settle for $2 million, two insurers paid, and a third sat on its rights and did nothing, forcing an insurer who was excess to pay to avoid the $50 million verdict that they expected at trial. In American Builders Insurance Company versus Southern Owners Insurance Company, the United States Court of Appeals for the 11th Circuit on January 4, 2023, ruled that the excess insurer who sued the primary for bad faith refusal to settle under the concept of equitable subrogation was entitled to a return of the money it paid plus interest. The facts of the case involved Ernest Guthrie, who fell from a roof and became paralyzed from the waist down, never to walk again. Within months, his medical bills climbed past $400,000, and future costs projected into the millions. The primary insurer for Guthrie's company was Southern Owners Insurance Company. Southern Owners refused to pay any amount to Guthrie to settle the claim, and American Builders and Evanston ponied up $1 million each. American Builders then sued Southern Owners for common law bad faith under Florida's doctrine of equitable subrogation. The record did not reflect that Southern Owners did anything other than request extensions of time to respond. On December 17, after internal discussions, American Builders decided to tender its limits. American Builders Council notified Southern Owners of the November 18 demand letter that would have resolved the claim for $2 million. Since Southern Owners was listed as the primary insurer, Council believed that Southern Owners had a primary obligation to pay. So he reached out to give Southern Owners a chance to step up before American Builders did. American Builders paid the policy on December 19, and Guthrie provided a release for the general contractor, Beck Construction. American Builders and Evanston paid the next day. At that point, Southern Owners, having only conducted one interview with the general contractor, ended its investigation. After the close of all evidence, the jury returned a verdict in favor of American Builders, and the district court entered final judgment for $1,091,240.82. The first and most significant issue in the appeal was whether American Builders proved a bad faith claim. Taking the evidence in the light most favorable to American Builders, a reasonable jury could have found, as it did, both that Southern Owners acted in bad faith and that bad faith caused American Builders to pay its policy. The bad faith conduct must directly and in natural and continuous sequence produce or contribute substantially to producing such damage, so that it can reasonably be said that but for the bad faith conduct, the damage would not have occurred. the 11th Circuit concluded that a bad faith inquiry is determined under the totality of the circumstances. Standard and the court must focus not on the actions of the claimant, but rather on those of the insurer in fulfilling its obligation to the insured. That said, a claimant's actions, such as a decision not to offer a settlement, remain relevant in assessing bad faith. The 11th Circuit concluded that there was enough evidence to allow the jury to reasonably find that Southern Owners acted in bad faith because it delayed acting on its duty to investigate and settle Guthrie's claim. The body of evidence could lead a reasonable jury to conclude that Southern Owners delayed its investigation instead of attempting to resolve the coverage issue promptly or using diligence and thoroughness. In that delay, a jury could reasonably find that Southern Owners completely neglected its affirmative duty to initiate settlement negotiations, while Guthrie's hospital bills climbed due to his traumatic injury. A reasonable jury could also find that Southern Owners' bad faith caused American Builders damages. When American Builders informed Southern Owners of Cohen, the lawyer for Guthrie's November 18 demand, Southern Owners refused to pay because it was still investigating the claims. Evanston had already tendered its $1 million policy on December 10, but the demand requested $2 million, so the next $1 million needed to come either from Southern Owners or American Builders. After Southern Owners balked, American Builders had no choice but to tender payment. Southern Owners' delay in investigating and settling led to its inability to tender an offer on December 18. As a result, a reasonable jury could find, as it did, that American Builders' damages stemmed directly and naturally from Southern Owners' bad faith. Southern Owners' contract with Beck Construction provided that no insured will, except at the insured's own cost, voluntarily make a payment, assume any obligation, or incur any expense other than for first aid without our consent. Close quote. This language requires the insured to obtain the insurer's consent before settling. The Florida Supreme Court, however, requires an insurer to establish three things in order to succeed on this affirmative defense. 1, a lack of consent. 2, substantial prejudice to the insurer. And 3, diligence and good faith by the insurer in attempting to receive consent. The first element has few exceptions. Even if the insured was obliged to obtain consent, the failure to do so is not an affirmative defense unless the insurer also establishes substantial prejudice and evinces good faith in bringing about the cooperation of the insured. A reasonable jury could, and of course it did, plainly find that Southern Owners did not show that it had exercised diligence and good faith. American Builders did everything when it came to investigating Guthrie's claim and deciding whether the insured should make a payment, all while Southern Owners sat back and watched. In my opinion, the key sin an insurer can commit in any claim situation is to sit back and watch others react while its insured is faced with a multi-million-dollar claim. Southern Owners sinned and was punished by the 11th Circuit. It is essential to every claim investigation that it be conducted promptly, thoroughly, and in good faith. Sitting back and waiting for the insured, the claimant, or co-insurers to act is a clear and unambiguous failure to deal fairly and in good faith to the insured, because it is depriving the insured of the benefits of the contract that was promised when Southern Owners issued a policy that insured Beck, who was allegedly responsible for Guthrie's injuries. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of each daily blog posting, usually 5 a week, sometimes more. You can also subscribe to these videos on rumble.com and youtube.com, and if you do, I'd appreciate it if you click on the like button or the rumble button. In addition, you might consider subscribing to my Substack publications and my locals community for additional important information and webinars that are available for a very small contribution. Thank you for your attention.